For those of you who don't know me, I'm Gregory Sisk. I hold the Loggy Distinguished Chair in Law, and I'm Associate Dean for Research here at the law school. But today I'm wearing my hat as a co-director along with my fellow co-director, Monsignor Martin Schlag of the Murphy Institute on Catholic Thought, Law, and Business. We seek to engage the church, the academic community, and the public in rigorous discussions about law and public policy, inviting those both within and outside the church to share thoughts on advancing the common good. This is another in our continuing series that we call Hot Topics, Cool Talk. Our mission with these programs is to invite people who have contrasting views on what may be very controversial issues, but having a civil discussion about it. And today's program is, can courts impose nationwide remedies for government wrongdoing? Universal injunctions allow a single judge to block a government policy across the entire nation and as to all persons, including those who are not parties to the case. And for many years, until the Supreme Court largely blocked this remedy, just this last term, universal injunctions had become a powerful but always controversial judicial tool. Should a single judge have the authority to halt a policy nationwide? Are universal injunctions necessary to protect individual rights and provide critical checks to executive overreach? After the Supreme Court weighed in, what is the proper scope of judicial relief and what remedies are still available? And we're delighted to have with us two guests to talk about these topics. Ilya Solman is professor of law at George Mason University and the B. Kenneth Simon Chair in Constitutional Law and Constitutional Studies at the Cato Institute. He is the author of several books, my favorite of them being Democracy and Political Ignorance, Why Smaller Government is Smarter. He also writes for a variety of popular press outlets, including the New York Times, the Washington Post, the Wall Street Journal, and CNN. And he is a regular contributor to the popular Volok Conspiracy blog on law and policy, which I encourage you as mandatory daily reading. Monica Heyman is a law professor at Northwestern and is a scholar on civil procedure, federal courts, and remedies. Her work examines the relationship between procedural rules and government power. Her latest article, which is quite pertinent to today's discussion, is Intervention and Universal Remedies, published in the University of Chicago Law Review. Professor Heyman previously clerked for two federal appellate judges and was managing associate in the Supreme Court in appellate practice at Orrick, Harrington, and Sutcliffe. So our two speakers will engage in back and forth for about 25 minutes to half an hour. And then we hope to reserve about 20 minutes for questions. I, as the moderator, will take the prerogative of asking the first couple of questions, and then we'll turn. So raise your hand when the time comes so that I get your attention. And with that, I'll turn it over to Ilya Solman.
Thanks to Professor Sisk, Monsignor, and the other organizers for arranging this, and to Monica for what I'm sure will be her insightful participation in this event. I myself, I'm not a civil procedure scholar or remedy scholar. I'm just an ordinary con law scholar, and I will try to focus on the big picture constitutional law issues here, though I'm sure we'll get into other issues as well. I will start talking about first why I think CASA versus Trump is a wrongly decided decision with potentially very harmful consequences. But then in the second part, I'll discuss how there are alternatives to traditional nationwide injunctions. And depending on how the courts use those alternatives and what the Supreme Court ultimately says about them, it may be that the harm caused by CASA v. Trump will be modest or even non-existent, depending on how things play out. So first, why are nationwide injunctions just and necessary as a part of our constitutional system? Because we want full enforcement of our constitutional rights, and we want full enforcement of constitutional limits on government power, not just executive power in the federal government, but also legislative power, the power of state and local governments, and so forth. And in many cases, it's simply not possible to have full enforcement of those constitutional rights and limits on government power without something like a universal injunction or some other kind of universal remedy, like some of those I will discuss later. In many cases, and the birthright citizenship case, which Casa v. Trump was, is a great example of this. In many cases, illegal government actions affect hundreds of thousands or even millions of people. It is simply not possible for all of them in many cases to bring their own individual lawsuits seeking their own individual remedies. And this is particularly true, as Justice Jackson points out in her dissent, when we're talking about people, many of whom are poor, lacking in legal sophistication, or politically weak, lacking in influence and the like. So if we don't have something like a universal remedy, we get what Justice Jackson rightly refers to as zones of lawlessness, areas where the government can engage in illegal action, often very harmful and oppressive, and for many of the victims, there is no possible remedy. This is not what our constitutional system is supposed to do. Our constitutional system is supposed to protect rights, liberties, and limits on government power universally. That's what makes it different from the British system and other European systems that we fought a revolution to get rid of, where indeed governments have zones of arbitrary power they're supposed to use. And this is from this perspective. Yes, thank you. I agree with that's an important point. And I think actually, this may be the single most important point in this entire discussion. It's not original to me. Others, have made it before. So it is from this perspective that I think much of the debate between the majority by Justice Amy Coney Barrett, she wrote the majority opinion in Casa, and a dissent by Justice Sotomayor, while fascinating and interesting and showing great skill on the part of both justices, I think they're ultimately debating the wrong point. What they're debating is things like what sorts of remedies were available in the English Chancery Court in 1789 or in some of the courts of the early Republic and so forth. And I think both sides have some reasonable arguments about whether there were remedies during that period that were fully analogous to modern universal injunctions. But I think, despite the great sophistication deployed in discussing this, this is actually the wrong question to ask. I personally, except as a matter of historical interest, I don't think we should care what remedies were available in 1789 in the Chancery Court in England because we fought a revolution to get rid of those constraints. The whole point was to have a system of government that would be different from what existed in England or elsewhere in Europe, and where also remedies are used to address the wrongs in the particular case and to deal with their full scope. And if that means creating a remedy that's somewhat different than what was available in the Chancery Court or in early American courts, then there's no reason not to do that. And there's nothing in the text of the Constitution or in the original meaning which says the only remedies that are available are those that were available in certain English courts or even in early American courts. But I would note that if you look at the debate between the two sides, and Justice Sotomayor rightly points out that there were remedies reasonably analogous to universal injunctions long before the modern period. We see them in bills of peace in the late 18th and early 19th century. We see them in a case like Pierce versus Society of Sisters, which many of you may be familiar with, especially at a Catholic law school, decided in the 1920s, where there was a universal remedy, not just against Oregon's ban on private school education. The remedy was not limited just to the Catholic school and a couple other schools that brought the particular case and so forth. I also want to emphasize that this is about third-party remedies generally and not just about particular geographic jurisdictions. And I want to emphasize that this debate is not simply about whether one individual judge can impose a universal injunction. It's even about whether higher level courts can do so as well, whether a three-judge panel, sometimes there are three-judge panels in various courts, or an appellate panel, or even the Supreme Court. By the logic of the Supreme Court majority in Casa v. Trump, no court can impose a universal remedy that goes beyond the immediate party to the case. The reasoning is not limited to one particular district judge or a so-called rogue judge. Nonetheless, I will briefly address this rogue judge issue, the argument that we can't have universal remedies as one single judge who might be a rogue or an idiot or a person guilty of partisan bias or that individual can then stop the wheels of government from working. My answer to that is if they really are a rogue, their decision can quickly be overturned on appeal, and circuit courts do in fact have procedures for handling cases quickly when they need to do so. So I think this is a greatly overblown problem. On the other hand, if that person is not a rogue and there really is government wrongdoing going on here, particularly on a large scale, then it's very important to have this broad remedy available. So if it really is the case that after Casa v. Trump, remedies are solely limited to the parties bringing the case, that would be a dire situation, and we would have vast zones of lawlessness potentially, not just by the federal government, but also by state and local governments. That is not often talked about, but the logic of the decision applies to remedies against state and local government wrongdoing, as well as the federal government, and that can be a serious problem as well, because state and local government illegality often does actually victimize people on a large scale. Just think about the cases involving racial segregation. When those cases were brought, fortunately, the remedies were not limited to the individual Black students and parents who brought the cases. Otherwise, we would still be litigating desegregation today because the issue would have taken that long to resolve. However, it is worth noting that there are various alternatives to traditional universal injunctions, and depending on how they work and how broadly they can be applied, they might resolve a lot of the problems caused by Casa v. Trump. One is the idea that sometimes complete relief to the parties in the case also requires relief to third parties. This will vary by the situation in the case, but it could work that way. This will be a useful tool in some cases. A second is class actions. Those of you who have taken civil procedure rated courses probably know about class actions. Sometimes it is possible to bring them, but you have to meet the requirements of numerosity. The group has to be large. Commonality, they have to be common interests. The person representing the class has to have so-called typicality. That is, they have to be typical of the class as a whole. And they have to provide adequate representation for the class. How difficult or easy it is to meet those requirements is going to vary a lot from case to case. Sometimes class action certification will be readily available, sometimes not. There is actually a debate among class action experts about how easy it should be to meet these requirements. A third possibility is lawsuits under the Administrative Procedure Act, those have a remedy called vacatur, which in plain English just means the government action is being challenged as vacated and nullified. There is a debate among experts about when and if the vacatur remedy is appropriate. I would note also that some executive actions are just not subject to the Administrative Procedure Act. And importantly, state and local governments in almost all cases also are not subject to the APA, which of course is about federal administrative actions, not state and local ones. Some states have their own versions of the APA, but others do not. So that's only a limited remedy. If you read Justice Kavanaugh's concurring opinion in Casa v. Trump, he says, don't worry, be happy, because ultimately these issues can get to the Supreme Court, and everybody will accept the Supreme Court decision as binding precedent. I will say a couple of things about this. One is that only a small number of cases can and will get to the Supreme Court. Indeed, the Supreme Court, its docket has actually been shrinking in recent years. To his credit, Justice Kavanaugh has actually complained about this, and he wants them to take more cases. But so far, the other justices do not seem terribly interested in increasing their workload in this way. Even if they did increase it to what used to be 200 or 300 cases a year as compared to the current 60 or 70, that's still only a tiny fraction of all the cases percolating through the system. Moreover, as a matter of legal reasoning, if you take seriously the reasoning of Casa v. Trump, then it applies to the Supreme Court no less than to lower courts. If it's just inherently illegitimate or improper to bring universal remedies, then a Supreme Court judgment also would not be universally binding. At most, it would be a precedent that future lower court decisions have to follow. but other victims of the government injustice in question would still have to bring their own cases in order to take advantage of the precedent. And for the reasons I mentioned earlier, often that will not be possible. A final possible remedy is lawsuits by state governments. State governments, because of the scale of their activities and interests, often need broader remedies in order to vindicate their rights and interests than private plaintiffs do. And we do, in fact, see a lot of state government lawsuits by both blue and red states in recent years. I think this is a valuable tool. I'm all for it, but there are limits to state government's ability to get standing, and also there are many rights violations or abuse of government power that for various reasons just simply won't attract state litigants. Private individuals shouldn't have to rely on the states to vindicate their rights. So if you add up all these 4 or 5 things, it may be that in combination, they will negate most, if not all, of the negative effect of Casa v. Trump. A lot depends on how broadly courts interpret when a class action is feasible, what complete relief is, when state governments are willing to sue, and so forth. But maybe in combination, most of the problem will disappear, and we either will not have zones of lawlessness, or at least those zones will be relatively small. But in my view, if that happens, and I hope it does happen, I really do, it might happen, I don't rule it out, but if it happens, then it will essentially mean that we will have universal injunctions, but we'll be calling them something different. And to my simple-minded way of thinking, if that's what happens, it might be better to just call a spade and just say, yes, we have universal injunctions, they're good, they should be used in particular instances where a legal government action really does affect a large number of people and where relief can only be brought through some kind of universal action. I'm not saying universal injunctions should exist in every conceivable case, but if they need to be used in a wide category of cases, we might as well call them what they are. That said, if I have the choice of calling them something else or not having them at all, I would much rather sort of call them something else because the substance matters more than the terminology. So on that note, I conclude and I turn over to Monica, but I very much look forward to discussion and questions. Thank you.
Thank you so much, Dean Sisk, University of St. Thomas, all of you, to the Murphy Institute for hosting us and having a very important and timely conversation. I'm not sure how much actual disagreement there will be between me and my colleague here, but I know that one big difference between what we'll be talking about is that I think that Professor Soman has talked about a lot of the really broad, important themes that have come out of the nationwide injunction debate. And I'm going to be digging in a little bit more to the brass tacks and some of the formal doctrinal questions that Trump v. Casa has opened up for us. Before I get into it, though, can I see a show of hands of how many 1Ls there are in the room? Awesome. Okay. This is fantastic. But I just want to make sure so that I'm not saying things that you may not have been exposed to yet in law school, so that we can all be on the same page here. So I'm going to cut my comments today into 3 different sections. I'm going to first talk about the Trump v. Casa decision that we had and the reasons why that may be correct or incorrect as a matter of law. And then I'll talk about how courts have responded to it so far. It hasn't been, we don't have a lot of information about how courts have responded to it yet, but we can at least cover what we do know. And then third, I will continue the conversation about what other forms of relief are potentially open and available to us now. So the crux of Justice Barrett's opinion in the Supreme Court comes down to a few logical steps. In a previous case, Grupo Mexicano, the Supreme Court had stated that Section 11 of the Judiciary Act of 1789 authorizes federal courts to issue equitable remedies, and those equitable remedies are based off of when that statute was passed, and so it's based off of the equitable remedies that were available as of 1789. So we're not getting into whether or not, as a constitutional matter, the Supreme Court can issue or any court can issue a nationwide injunction. It's just a question of whether or not Congress has told the federal courts that they can exercise that power. Because we need to have some kind of an analogy to the kinds of remedies that were available in 1789, we need to look at the history There is nothing there at the time that was in the same kind of scope as what a nationwide injunction is. And so based on following those steps of Justice Barrett's logic, because we don't have a historical analogy, there's nothing that we can say tells us that Congress meant for us to have this power. I agree with some of that analysis. So first, I think that Justice Barrett's understanding of the general practices of courts in equity, that usually those cases were brought by and against individual plaintiffs, where usually we're concerned with who the particular parties were, and courts weren't granting relief that extended beyond that. I think as a general matter, that was right. And that courts were trying to reward complete relief to the parties, even if that might have had incidental effects on other people, but the relief itself was always limited to the party. We were telling the defendant, you have to stop pouring the toxic sludge into the river because that's harming the particular plaintiff who is sued. But the fact that there will no longer be toxic sludge in the river happens to incidentally affect and benefit lots of other people. But we're still only telling the defendant to stop pouring stuff in the river for this particular plaintiff. Second, I agree that Justice Barrett is probably reading Grupo Mexicano faithfully to how Justice Scalia wrote that decision. So that decision said that there was some flexibility in how equity was put into effect by the courts, but I agree with her that Justice Scalia probably did not use the term flexible to go so far as nationwide injunctions. Yes, we have some flexibility to respond to new issues, but not to create a whole new thing that is outside of the scope of what we've ever done before. Third, I also think that Justice Barrett made some very good points about the role of the federal court system in relation to the executive. That courts are about providing relief to particular people who come before them and prove that they're entitled to the relief. Courts are not in the business of generally declaring what the law is if it's not tied to some form of relief. But I think that's where our agreement ends. So this is where I'm starting to get really into the brass tacks here, and I'll try to explain this for the folks who haven't yet covered this in their classes. So to start, Section 11 of the Judiciary Act likely is the wrong source to look to for the court's equitable powers. Section 11 is a jurisdictional statute that gives federal courts the power to decide 3 different categories of cases. So it tells the federal courts that you can hear cases that are involved the United States as a plaintiff, not as a defendant, but if the United States chooses to sue, it gives the court jurisdiction over that. Where an alien is a party, so where we have a non-citizen who is a party to the case. And third, in suits between citizens of different states. So diversity jurisdiction, if you guys have covered that, I'm seeing some nods, excellent. Okay, we know a diversity jurisdiction. So it includes that. But CASA, that decision did not fit into any one of those categories. The CASA decision was based on federal question jurisdiction, where you have a claim that arises under federal law. A few less heads, maybe a few, okay. So diversity jurisdiction, citizens between different states. But here we have a federal question case. We have a federal cause of action and they're suing on that, which means that it comes from a different jurisdictional source, which is instead 28 USC section 1331. That's what authorizes you to get into federal court based on a federal cause of action. If Justice Barrett is right, that the court's equitable powers stem from jurisdictional statutes, that those kinds of statutes are where we should be looking for the court's equitable powers. Those statutes freezing the remedies at the time when those statutes were enacted would at least mean in the CASA case that we should be looking at when Section 1331 was enacted, which was in 1875, as opposed to 1789. But I think that it's also questionable to be looking to a jurisdictional statute at all. And that gets into Erie. Have you guys talked about Erie? Oh, yes. Oh, I see a very excited face. I love that. Yes, Erie is very exciting. That is the proper reaction. But just for those who may not have had a chance to cover it yet, Erie was the decision that revolutionized the way that federal courts work when you have a state cause of action that's coming in, but also how federal courts were viewing their own powers to come up with what federal common law was. So before we had Erie, federal courts were authorized to be looking out to what the general common law was out in the world. They understood themselves to be trying to figure out what that was and applying it to the case at hand. We're not looking just to written law like statute, something. We're instead looking out into the ether to find what the common law is and apply it. That's how federal courts understood their work to be. After Erie, and after a revolution in how we think the law has worked, what we call positivism, where now we're looking to a positive written source of law for the powers that the court exercises. After Erie and that revolution in how we think, nowadays we have to have some kind of written source of law to tell the courts that they can exercise particular powers. So we're always looking for that written source. But that's not what federal courts thought they were doing before Erie. Instead, because they were looking at what this general common law was that was out in the ether and that they were trying to figure out what it was, they didn't see that as being frozen in time. The common law was something that developed over time because courts were figuring out what the content of that meant over time. And so the remedies were also responding to what the courts were discovering in the common law. And so it wasn't frozen based on what courts were told they could do at one time. Instead, it developed over the course of federal court adjudication. So I think at least that the court in CASA needs to do a lot more to explain why Section 11 of the Judiciary Act, which was adopted before Erie, when federal courts saw their power as something that could develop over time and not based on one particular statute, why it is that we should be reading Section 11 nowadays, after Erie, to require some kind of positive limitation on the court's power. I'm worried that this is an anachronistic reading of these particular statutes. I also think that Grupo Mexicano may have been the wrong precedent to draw on. That case was a diversity suit, not a federal question case, and so didn't seem to address the issues that were at issue in CASA. Because it's a diversity suit, it had a different source of power than the federal question one. My last point on the Trump v. CASA decision is its discussion of class actions. So Justice Barrett said that we can't look at this one form of equitable relief that used to be available called Bill of Peace, where one person sued and they said, I am representing lots of other people who are in my situation, and when you grant me relief, you should be also granting relief to all these other people who are not parties in front of the court, which sounds potentially a lot like a nationwide injunction. But she rejected that analogy and it said instead that that is a precursor to the class action. That's not about nationwide injunctions. That's about when people can represent other people who are in a similarly situated position in front of the court. The problem with that reading is that Rule 23, which authorizes class actions under the Federal Rules of Civil Procedure, is about the process for certifying a class action. It creates that as a procedural mechanism, but that doesn't change the scope of the court's remedies. So those remedies have to come from something else outside of the Federal Rules of Civil Procedure. They can't be something that is specifically authorized once you've certified a class. Now suddenly we've opened the door to allow lots of other remedies that the court can issue. And that's because if Rule 23 did authorize the court to exercise remedial power that the court otherwise wouldn't have if a class hadn't been certified, then that would violate the Rules Enabling Act, which authorizes those federal rules to be enacted. So the Federal Rules of Civil Procedure aren't allowed to abridge, enlarge, or modify any substantive right. And so if they were authorizing different remedies, if you had certified a class, then that sounds a lot like enlarging or modifying your substantive rights, because it changes the kind of relief that the court can issue you. And so if Justice Barrett is correct that Rule 23 is doing something different or is authorizing remedies that are analogous to our historical remedies alone, they're limiting that, I think she is unfortunately probably getting into a territory of Rule 23 violating the Rules Enabling Act. All right, so how have courts responded? Setting aside whether Trump v. CASA was correct, In many ways, things have continued as usual. We've seen courts that are certifying incredibly broad class actions, and courts even issuing pretty broad, although not completely universal relief. So maybe we're not going to say that this applies to everyone in the country, but certainly every non-citizen who falls under the statute, which sounds very similar to universal relief. And that's happened before the court has actually certified a class. So one of the issues that we'll see when we get into are class actions going to be the solution going forward is, do you have to certify the class before the court grants relief, or does that have to happen after? And one of the purposes of preliminary injunctions, which are the form of nationwide relief that happens at the very beginning of the case, one of the whole purposes of that form of relief is that courts are protecting their ability to continue adjudicating the case. They're trying to preserve the status quo so that if they just let things continue on as normal, they might no longer be able to adjudicate the case, say because a non-citizen has been deported, and so they no longer have power over that person, or they've stopped paying out the money to this organization and the organization has had to close up shop, things like that. The court's supposed to be able to issue preliminary relief so that it can keep adjudicating the case. And the question is, if we no longer have universal injunctions, are we going to allow the class action mechanism to step in and provide the avenue for courts to do that? So we've already heard a lot about class actions. I think that's one of the problems that's going to happen going forward is, can courts issue relief before it's fully certified the class? Another issue with class actions is how much information you need at the beginning of the case. Because what we've seen with the second Trump administration is that the administration is willing to move incredibly quickly to put out executive orders or federal agency actions. And so plaintiffs who want to sue about those need to be able to move very quickly to get into court to respond to them. And if with a class action, in order to meet all of those elements that you heard listed out earlier that Rule 23 requires, you need a lot of information about the class. And so are we going to require them to have all of that at the very beginning of the case, which is going to hamper their ability to get relief quickly? Or are we going to skip or subtract down that doctrine as it applies to this kind of public interest litigation? We also talked about state litigation earlier. I'll just add one other note to what we've already heard. I think state litigation is incredibly problematic. One, because it takes money away from how states are able to provide services. Your state is instead pouring money into a fund for their lawyers to be challenging executive action, money that could be going to other services that they provide to their people. Second, when you put all of the eggs in the state basket, the issues that they're able to raise are usually questions about their state budget. So they'll challenge DACA because it's affecting how much money they have to spend from their coffers. Or if they want to be preserving DACA, they may say, we already spend a lot of services on these people, and we're gonna be forced to change how we do that going forward. It's gonna be a question about state budgets, not about the actual issue of people who are being affected by these laws. We're gonna lose the stories of the individuals who are actually affected and instead be having debates in court about how much it's affecting particular state budget lines. Finally, and then I'll sit down and we can open up to questions. One of the issues is going to be how much courts are willing to turn away from the injunction or vacatur, which is another very famous, commonly used universal form of relief where we're negating a federal action. How are we going to be, what other kinds of forms of relief are we going to be looking at if those aren't on the table anymore, or if courts want to avoid the controversy over using them? One option is the declaratory relief. So instead of telling the government that you have to do something or not, instead what the court can do is declare what the law is or declare what the rights of the parties are in a case. So instead of saying you are barred from deporting this individual, we're going to say they have a right to stay in the United States, and I am declaring that, the court, but I'm not actually forcing anyone to do anything in response to that judgment. If court watchers are correct in their observation that it seems as if the Supreme Court right now, it doesn't want to force a confrontation with the executive by telling them that they have to do something, and then the federal government ignoring that order, if they're trying to avoid that, Declaratory judgment might be an intermediary step where the court can say, this is what we're telling you the law is, and then hoping that the federal government complies with that. Now, we might have a situation where the government chooses not to comply with it, and then we're back in the same problem. But it provides the court at least with that initial step so that we can figure out what the correct law is on an issue, as opposed to putting all of the eggs in whether or not the court is going to be able to grant relief at the end of the day or not. So with that, I look forward to all of your responses and questions.
So thank you to Monica for a very insightful presentation. As you can see, she, unlike me, is a true remedies expert, and I agree for it's worth at 95% of what she said. I just want to briefly expand on a couple points. One is, I think she's right that the 1789 Act may not be the right act to look to, and the federal questions is more appropriate. But even if we do look to the 1789 Act, that act nowhere says only those equitable remedies that we use right now or that are used in England right now are permissible. Rather, the whole point of an equitable remedy is to fully remedy the wrong that is being dealt with. And if that means using somewhat different tools than the exact ones that were used in England in 1789 or in the US in 1789, then that is what should be used. That gets me to my second point, that Monica is right that at least in the pre-Erie era, the courts thought that they were discovering the true common law and that they could adjust it and expand it over time. But I would go further in that and note that in the founding era and also in the 19th century, when they had the Reconstruction Amendments, which also often require equitable remedies, the understanding was that much of what is being protected by those constitutional provisions is not just a matter of positive law, but a matter of natural rights, fundamental human rights of the kind that the Declaration of Independence refers to, life, liberty, the pursuit of happiness, or John Locke, we discuss as the rights to life, liberty, and property. And if it is the case that the idea is to protect these rights as fully as possible, then the remedies should follow the scope of the rights violation and not be limited to particular tools that might have been used by a particular court at a particular point in time. At least if you're an originalist, this natural rights understanding of what is being protected should matter to you. If you're not an originalist, you can say, I don't care what a bunch of dead white males in these 1700s thought our rights were supposed to be, but the Supreme Court majority was deciding Casa v. Trump. They are originalists, or at least they certainly say they are, and they try to apply originalist precepts in general. And if they apply here, then these natural rights understandings are important. Even issues about the structural scope of government power, they often had some sort of natural rights or philosophical foundation. Is the idea that natural law dictated a particular scope of government power in particular areas, and that there was an inherent essence to executive power, legislative power, the like that often is supposed to apply. Another issue is with class actions. Monica is absolutely right that it often will take time to establish whether the four requirements are met. What courts have been doing in a number of cases is certifying so-called putative classes. We've seen this in Alien Enemies Act cases about deportation and some other cases. Well, they basically say we're provisionally certifying this class, but subject to a later determination whether it can truly be certified. And the Supreme Court seemed to bless this move in AARP versus Trump, one of those sort of midnight Alien Enemies Act decisions. But the Supreme Court has not yet issued anything like a complete opinion as to when putative classes are permissible and when they're not. And also at what point do you finally have to decide whether a putative class can turn into a real class? All of this is sort of for the future and will help determine to what extent these alternative to universal injunctions really will be adequate. Finally, with regard to state budgets, I have a slight disagreement with Monica in terms of the actual costs here. The litigation costs, even for small states, are probably only a very small portion of their total state budget. So I don't think there's much danger of large amounts of money being diverted from healthcare or education or the like. It is true that as a legal matter, when the states bring these cases to get standing, they usually have to rely on effects on state budgets. That's how state plaintiffs got standing in the birthrights, in some of the birthright citizenship cases. They said, well, these babies aren't entitled to birthright citizenship, then states don't get as much money in their budget. And you can readily think like, this is not actually the truly important issue at stake. The truly important issue at stake is whether these children are subject to deportation, in some cases to horrible conditions. And the effect on the state budget is very much sort of a secondary matter. But the effect on the state budget does enable states to bring these cases. And once they bring them, they can articulate these broader issues as well. And often they can do a pretty good job of doing so. What I'm concerned about is that in many situations, states will not have the incentive to bring cases, or there might not be enough of an effect on the state budget for them to get standing, or the effect might be too indirect. There are jurisprudence on when states can get standing based on their budgetary effects. To put it mildly, that jurisprudence is not a model of clarity, and therefore it is often hard to tell whether a state really can bring a lawsuit or not. So on that note, I conclude, but I look forward to Monica's response and then to the discussion. Thank you.
Glass of water. I forgot to bring my bottle of Diet Sprite with me too. For those of you who have civil procedure at 1:30 with me, don't worry, we can start a little bit late and we'll be fine. So you don't need to get up and go. So I want to ask a question of each of our speakers, and I'll start with Monica. And this will involve some additional civil procedure that most of you have not had at this point, and that's talking about claim and issue preclusion. So one of the rules about preclusion as applied to the federal government, one of the historical rules, is the federal government is not subject to non-mutual collateral estoppel, which means the fact that they lost in a case previously cannot be used against them offensively by a plaintiff to force them to lose in a second case. And the rationale behind this is that it is important that these major issues continue to percolate in the lower federal courts with different debates, different decisions before the Supreme Court resolves any conflict. But a universal injunction stops that process cold. There's not going to be any continued, thank you so much, any continued percolation, because the first judge who issues the universal injunction shuts down that debate completely. What about that aspect of universal injunction?
So this has been a major criticism of the nationwide injunction generally, that the Supreme Court shouldn't have to address issues after just one district judge somewhere in the country has decided that a law is unlawful, and then it immediately gets appealed up to the Supreme Court, and they have to figure out the right answer without having the benefit they usually get in lots of other cases of having lots of very smart district and circuit court judges weigh in on the issue. I'm not sure how much percolation actually helps in cases where, like in the citizenship question, where we have lots of different amicus briefs, people are weighing in and providing the Supreme Court with perspectives, or where there's already been a lot of scholarly work on the question that the Supreme Court can draw on to address it. When I think the citizenship question was probably the best example of where the executive was doing something that a lot of people viewed as very clearly unlawful. And the question was just going to be whether or not the Supreme Court was going to be complying with that attitude, or if they were going to try to create some kind of exception for the government, and we'll see.
No, I thought you were finished. Go ahead.
But the question about one of the benefits to class actions as a response to getting rid of universal injunctions is that it does prevent people from going back to the federal government and getting several bites at the apple. So before, it used to be that the federal government would have to defeat every single possible case against it. And if it lost even one and you issued a universal injunction, then that would apply to everyone, even those people who had previously lost their own challenge in the past. And so at least with a class action, that's going to mean that everyone who is represented by that class gets that same bite at the apple. And so the government isn't going to have to defend against lots of those cases. But unfortunately, I think that undermines the percolation, because then it means we're all focused on that one case as opposed to having lots of other potential cases.
So a question for Ilya. I want to talk about the rogue judge, which I'm going to suggest is kind of a red herring on both sides of the argument. So to begin with, let me say, just to bring the full gamut or range of issues here, I think Justice Barrett got it exactly right in Trump versus Casa, both in terms of the approach that she took on the equitable powers, but also in her discussion with the Justice Jackson dissent, which goes to some of the issues that Ilya wrote. What makes the case strange, it seems to me, is the underlying issue on the merits, birthright citizenship, because the Trump administration's position on that, in my view, is so obviously wrong. And so we look at that and we say, well, why doesn't the majority ever engage with the fact that one of the issues to grant a stay is the likelihood the government's going to win, which here it should be the likelihood is the government is going to lose, because their position on birthright citizenship is so wrong. And so it makes it kind of an odd case. I wonder how different some of those in the audience might feel if instead it was the Biden administration arguing against the universal injunction, as they did. This is not a partisan issue. When a court has enjoined the Biden administration from offering relief on student loans, saying that that's unconstitutional and universally so. So no, not just with regard to the states that have challenged it, but across the nation, student loan relief will be shut down. So what about the ordinary type of case, important constitutional or statutory questions, but there really are reasonable arguments on both sides? The problem with the universal injunction, the government would say, is if 10 lawsuits are brought challenging that, and we win on 9 of them, but the 10th district judge issues a universal injunction, the fact we are batting 900 doesn't prevent that one judge from setting aside the policy as to the entire country, as to everybody. And I'm not saying that's because the judge is a rogue. It was a debatable question, but still batting 900 is pretty good. The government gets no benefit to that. Why should, or as Justice Barrett put it in her response to Justice Jackson, executive imperialism is a bad thing, but so is judicial imperialism. And when one single judge can shut down everything across the country, isn't that just substituting judicial imperialism for executive imperialism?
So thank you for that question. I think I kind of prefigured my response in my presentation when I pointed out that it's wrong to think of this in terms of one judge, because a decision by one district judge is subject to review by a court of appeals, which at least 3 judges on the panel, and they can overturn if he really is a rogue or just has the bad arguments or whatnot. It can be reversed. A 3-judge panel, if they're rogues, is subject to en banc review. When an en banc review is particularly likely to be used when there's some major government policy has been set aside for problematic reasons, and as Harold turned Justice Kavanaugh's point against him, the Supreme Court is also available in cases like that as well. I'm not saying this will prevent all possible bad decisions, but if I have to choose between allowing vast zones of lawlessness of the kinds that Justice Jackson described versus the rare situation when a rogue judge gets away with something and neither the Court of Appeals panel nor the en banc Court of Appeals nor the Supreme Court decide to do anything about it, I'd say that second risk is much more acceptable than the first. And for the record, I said the same thing about the student loan decision as well. This might not be the right thing to say in front of an audience of students, many of whom have student loans, but I thought Biden acted illegally in that case. I wrote about it at the time, and it was an abuse of emergency powers, and it was problematic in various ways. And I think it was good that there was a universal injunction so that he, in fact, could not improperly spend hundreds of billions of dollars from the Treasury, which is a congressional power, not an executive power. He was wrongly usurping congressional power in that instance, and it was good that there was a nationwide remedy. And more generally, this is a whole separate subject, but I think when government funds are illegally spent. There should be taxpayers standing to challenge that because the taxpayers are the real victims there. In the student loan case, the Biden administration, their real strategy was to hope that nobody would be able to get standing to challenge this because the Supreme Court has wrongly, in my view, held that taxpayers, with rare exceptions that wouldn't apply here, do not have standing to challenge illegal expenditures. And I think that's wrong because the taxpayers are actually the ultimate victims in most illegal expenditure cases.
And with that, questions from the audience? Found all of you.
Everyone completely agrees
Things
with what
to
we
think.
said.
It should be hard to do because we don't agree on everything. So you can't all agree with what we said. Yes, please.
And down the street at the other law school, there's a young, talented law professor who believes that birthright citizenship doesn't exist. Would you care to speak about the substance of the case in opposition to our friend Professor Woolman?
Sure. Elon Werman and I work for the same federal judge, though at different times. In fairness, he does not believe that there is no birthright citizenship for everybody. What he believes is that there isn't birthright citizenship for children of illegal migrants, and possibly here, he's not very clear, for children of migrants who are here legally but on temporary visas. And he has claims that, well, the issue is that their parents don't have the proper allegiance to the United States, have an allegiance to another power, and that illegal entry inherently prevents the proper allegiance from forming. I and others have a long list of reasons why Werman is wrong. I will just mention one because I think this one doesn't get sufficiently emphasized in the debates over the subject, and that is that the major purpose of the birthright citizenship clause of the 14th Amendment was to grant citizenship to freed slaves. And if you accept Werman's arguments or pretty much any of the other arguments made for the government side in these birthright citizenship cases, there will be large classes of freed slaves who also would not have been entitled to citizenship. For example, many freed slaves were actually people brought in illegally to the United States during the period after 1808, when the federal government had banned the international slave trade, but many thousands of slaves were illegally brought in anyway. So by this standard, those many thousands of people plus their children would not have been eligible for birthright citizenship. If the idea is that as Werman and his co-author Randy Barnett said in their original New York Times op-ed about this, if the idea is that illegal migrants haven't made an allegiance for protection bargain with the federal government, whereas people born to legal residents, they had done this, their parents had done this, then it's very obvious there was no allegiance for protection bargain between slaves and the federal government, because of course, far from being protected by the government, slaves were horribly treated and exploited and oppressed by the federal and state governments. I won't go through other issues in this debate, but all of these other arguments have the same problem, that if you accept the reasoning of the other side, there would be large classes of freed slaves that would also not be eligible for birthright citizenship. I think this alone is enough to reject these arguments, but they have a bunch of other weaknesses too that we could have a whole separate event about if we wanted to.
Any thoughts? Yes, please.
Have in my hand cards that I hand out to people that I think are immigrants or know that are immigrants. For example, I had I'm in a condo, and they just a whole host of them changed were there, and I was worried about them any kind of an ICE raid that might take place. So I gave him some of these cards. And my question is this: what rights, human rights, do immigrants have under the law? And it was kind of articulated in how that applies to what Judge Coleman Barrett wrote up. Did she recognize any rights for immigrants today?
maybe a brief response. I don't want to go too far afield because that's not, while this was a birthright citizenship case, that's not what the discussion's about. I mean, I can answer the question about Justice Barrett, which is she did not comment on that issue. She didn't comment on the merits of it. She didn't say anything negative about immigrant rights. She didn't say anything positive about it. It's simply, I was just pointing out, it seemed to be in some respects an odd case to make a decision about rejecting universal injunctions when the merits of the underlying case seem to be on the government side so weak. Anyone else? Yes.
Any thoughts on Justice Sotomayor's dissent? If you agree, disagree.
I'll turn that over to you.
So I think that Justice Sotomayor and Justice Jackson were making an argument that was largely based, and I think Professor Stolman would agree on this, that it was largely based on a different view of what the court's role is in our federal government system. That courts are supposed to be providing a remedy generally in order to respond to what the federal government is doing. And so if there is a harm that you are suffering, courts should be able to think up and apply a remedy that fits with that harm. And if nationwide injunctions are what's required in order to fix that, then so be it. One of the problems with that is that it may be problematic if we try to apply that broadly to everything that we've done in the past, because we do have a tradition in the United States of having some rights that we either don't enshrine in the law. Some of that is for non-citizens, in fact. Non-citizens aren't entitled to full constitutional relief, and we've instead applied only some of them. And when individuals are asking courts for relief, they have to be looking to a written source of law that authorizes them to do that. You may all remember qualified immunity as one of the big points of contention a few years ago, that people can sue, that we all understand that you have been harmed, but that the law doesn't provide you with any kind of a remedy. And we can disagree with those doctrines and think that they're incorrect, but we do have a tradition of not providing a remedy necessarily to every right. And so I think that the underlying concerns that Justice Sotomayor and Justice Jackson have with this system have the right background, the right heart in them, and that we should be looking at how we can expand remedies and authorize courts to respond to rights that are asserted. But I don't think that that's where we should be looking to, at this kind of amorphous idea of having a remedy for every right as the source of power for the court.
Just briefly on this, qualified immunity is a bogus doctrine that should be gotten rid of. It's not just Justice Sotomayor who thinks so. Clarence Thomas has said much the same thing. It has no basis in text or original meaning, or really anything else other than sort of pragmatic concerns. We don't want to, we don't want to impede government officers too much or subject them to too much liability. And I think, more generally, other obstacles to fully remedying rights are also incompatible with the fundamental precepts of our constitutional system and also should be gotten rid of. There can, I agree, to be certain instances where some people are entitled to certain rights and others are not. That goes to the substantive nature of the right or the other legal doctrine in question. It doesn't go to a separate issue about whether remedies should be universal as opposed to particular.
So when we talk about these issues about judicial remedies, you can see it can go pretty far afield to talk about a lot of things, including for those of you who have been coming to Hot Topics Cool Talk, we've had a program on qualified immunity and debated that subject as well. So we've reached the 1:30 hour. Let's thank our guests and please keep coming to these programs.